And welcome to the Open Forum. Resoundingly, it's the season of bells. You didn't create much of a ruckus, so I didn't have to ring it loudly. This is the Open Forum for anyone new on the block. Welcome back to anyone who's here after a long time, including our speaker. We're here every Wednesday at 8, except for Boxing Day. We won't be here on Boxing Day because everyone else is doing something else. The Open Forum has been going for 47.5 years at 10 Shepherd Street Humanist House every Wednesday at 8, hail, rain or shine, and with a different speaker, controversial, fascinating and topical. But no opinions expressed have any connection to the Humanist Society of New South Wales, who own the building and give us house room every Wednesday. This is not a humanist meeting. This is a meeting of the Open Forum, which meets at Humanist House. That's a very important technical distinction. Your opinions are your own. We welcome all opinions without fear or favour. That's why we're here, to live and to learn. Tonight's topic, trial by jury, our inalienable right. I'd like to welcome Dr. John Wilson, who's back here after, how long is it since you've been here?
Between 10 and 15 years.
Okay, he spoke here a long time ago, and I think it might have been on a similar, related topic. But anyway, trial by jury, welcome John Wilson. Thank you, sir. So you can sit down if you like.
Thanks,
Are you a judge?
Am I a judge? We're all judges.
Well said.
That's the whole point. Every juror is a judge. And in a democracy, we govern ourselves. But unfortunately, we've been brainwashed out of the right way of thinking. And it's all in fact, on one track mind. I was on the same track last time. I will never move from this track because there is nothing surer than the truth. And the truth has been around for a long time, but it's being suppressed. And in fact, I've just come now from Sydney University where they're holding a seminar, and it's called corporatocracy. Yeah. And this fellow, he's giving his speech, and he's complaining all the time, complaining about how corporations are taking over the country and all this. But there are so many whingers and so many people exposing, like the CEC or whatever, they're exposing all the wrongs and the ills, but they are not coming up with a simple solution. The simplest solution has been around for 800 years. Very wise men back in 1215 decided they've had enough with being trampled on and destroyed by this tyrannical King John. And so they got together in Bury St Edmunds and drew up the Great Charter of Liberty, of freedom. And in fact, this picture here commemorates that. This is a picture that I took one of the visits down to Canberra. That is called the Magna Carta Monument. It's in Magna Carta Place, in front of the Parliament House. And nobody knows it's there. Because you are not allowed to know your heritage. Our heritage comes from that. Because when they decide, oh no, we're not going to be put up with being slaves and cows being stolen and beaten by the monarchists and so forth. They said, no, we're going to stand on our own 2 feet. And so they drew up a common law writ. This is before Parliament. This is common law because it's the law of the people, by the people, for the people. Now these people got together and they said, no, we're going to put our foot down and make these demands on the bullies and the monarchs and so forth, and say, this is how it's going to be. And there's some talk that it's not valid because they held a dagger to his throat and said, you'll sign this, won't you? But that's beside the side because the common law writ is fundamentally 100% 100% beneficial. In fact, it's called the landmark of democracy. And this is where it comes from. Democracy is a Greek word meaning people rule. And in fact, you have various forms of regimes. You have a monarchy where a king or queen has sovereignty. And sovereignty is a much bandied about word, but it basically means the ultimate authority to make and impose laws. Okay? And then you have another thing called a republic, which is means away from, okay, the people, republic, and where you have the parliament laying down the laws. And then you have a democracy where the people lay down the laws. And they, in a parliament, they make laws for the state. In other words, they make statutory laws for the state. Okay? And that's for the management and good governance of all the assets of the country. But then you have the Commonwealth, which is made actually in courts, whereas statutory law is made in parliaments, and parliament is not government. They will say, oh no, the Rudd government, the Howard government, the Morrison government, whatever. They're not. There's a big lie. We've been fed lie after lie after lie and never told the truth. Once you tell the truth, you're a tall poppy and they'll cut you down. They'll assassinate your character, they'll put you in jail, assassinate that, and because they don't want people getting out of control. The elitists and the bullies want all the benefits for themselves, you know. This revolution came about again in the 17th century when they had another bad king, King Charles. And there was the ding-dong between the monarchists and the purists. The purists were led by Oliver Cromwell. And eventually they convicted King Charles of high treason because he'd actually brought in foreign troops to fight his own people. That was high treason. Pretty easy to do. And so when they decided, they convicted him of high treason, cut off his head. And as soon as they cut off his head, a couple of weeks later, they brought in an act to abolish the office of king. I've got all the details here, and in fact, over on that table, there's a sampling of some of the research I've done. But the whole thing is that when they abolished the office of king, no one could stand up and claim as a pretender that they had a right to be the king. And then within a couple of weeks after that, they then had another Act of Parliament, and they declared England to be a commonwealth. A commonwealth without any king or House of Lords. That was it. And that commonwealth lasted for about 11 years, from 1649 to 1660. Oliver Cromwell died in 1658, but his son couldn't hold it together, and eventually the monarchs came in and restored the crown. And in fact, as far as English history is concerned, and documentation, the laws of England, if you go to the library, I found this, and here we have the statutes at large in the State Library. And it says, this is volume 2, which goes from 1509 to 1641, and then volume 3, consecutive numbers, goes from 1660 to 1707. Now there's a whole wedge, and here is that wedge. They've put the acts from the Commonwealth Parliament separate. So in other words, you cannot have a king and a Commonwealth at the same time. And yet we've been told these lies, and it extends into the courts and the parliaments and so forth, and trial by jury has got a very big part to play with that, because the purpose of trial by jury is to get to the truth. to get justice. But they won't allow trial by jury in our courts. In fact, what they are taught at the universities is that the Parliament has sovereignty. I quote this from a transcript. The Parliament has sovereignty and decide what cases will have trial by jury. In other words, you do not have, according to them, the right to the lawful judgment of your equals. So in other words, you do not have democracy, because trial by jury is democracy. In fact, for quite a few years I had my supporters wearing these t-shirts. Now we wore these t-shirts to courts, and it caused quite a ruckus. We had one riot in the High Court, where the High Court judges refused me trial by jury, and then we had another riot in the Supreme Court, where again this judge refused me trial by jury, and the second time there was quite a ruckus in the court. They threw me out, and while I was in the outside of the court, I could hear all the bashing, crashing, and then they dragged out two blokes, Peter Rutherford and John Bowskis, and they charged them with contempt of court. Contempt of court for wearing that. Yeah, and then they put them in the cells and brought them out the following day. And the judge, who was a fellow called Michael Adams, he said, "Are you going to apologise?" And they said, no, we're not going to apologise. And so he let them out on bail. But there was a barrister from the Crown solicitors, and he said, well, Your Honour, you're laying this charge of contempt in court. You can't try the case. And he says, well, I'm going to do it anyway. And the barrister from the Crown Office said, as Your Honour pleases. So in other words, we've got a dictatorial judiciary who will not allow people to have their rights. And this is called a kangaroo court. Now, a kangaroo court, by definition, is a court that acts unfairly or dishonestly, or disregards legal rights or disregards legal procedures. They do the whole lot. Because every time you go to court, in a commonwealth, in a democracy, you are entitled to the lawful judgment of your equals. But when you get in there, they say, no, you don't have it. This is a summary offence or whatever. And Peter actually ended up apologising, which is quite quick. And so that left John Bowskis. And so the next time they had John Bowskis in court, he said, I challenge the jurisdiction of the court, which is what we all should do. And Adam said, on what grounds do you challenge? And he said, I don't give my consent to being tried summarily without a jury. And the judge said to John, your consent is immaterial. Your consent is nothing. So therefore, as far as I'm concerned, this constitutes being a slave. Because a slave has no right of consent, has no right to property, has no right to trial by jury. In fact, when you look at your title certificates on your land, you're not the owner, you're the tenant. You are the tenant, you're not the owner. In fact, I brought this up in the Supreme Court one day. I said, I want my title changed from being a tenant to being the owner, because I bought it. And of course the judge would not allow a jury, and so he dismissed the case. In fact, I've been to court many, many times demanding trial by jury, trial by jury, trial by jury, challenging, denied. And so they finally got sick and tired of this, so they charged me with being vexatious. Okay? In other words, annoying without grounds for action. And I said, hey, I might be annoying, but I've got real grounds for action. And that actually constitutes outlawry, because they are taking you outside the protection of the law. I am not allowed to go to court. Now, I've been assaulted by police quite a few times. One time they broke into my house, threw me on the ground, choking me. Another couple of constables had to pull this bloke off. I tried to charge him with attempting to choke, which is 7 years in prison.
Mm-hmm.
But the judge would not allow it. He said, no, case dismissed. Okay? Another time, they dragged me into the cells in Parramatta, and they said, we've got to take your photo and prints. I said, no, you got that many times, don't forget it. And so what they did, they dragged me out. I got on CCTV. Okay. But by doing so, they actually twisted my leg, and because I've got very bad knees, I only just had, I've had 4 operations on the knees, and so I was on the floor, the Parramatta cells, in agony, for 40 minutes before the ambulance turns up. I could not prosecute those constables.
Mm-hmm.
In other words, I'm an outlaw outside the law. In fact, around the what they call it, rotunda here, it's in Latin, okay? And it says, no free man shall be taken, indeed imprisoned, or exiled, or outlawed, or dispossessed, or destroyed in any way, nor shall we pass over him, nor shall we send over him, unless by the lawful judgment of his equals, which is the law of the land. That is the law of the land. And it goes on to say, to no one will we sell, to no one will we deny or delay right or justice. But that just backs up the first part. So this immortal phrase should be taught in every school. Should be taught in 3rd class, reinforced in 4th class, and then on to high school, where people are taught their real rights under common law, as our heritage and our traditions dictate. But this is not being allowed, because that will put the power into the people's hands. In other words, the people will rule. And there's a very famous American called Thomas Jefferson. He said, if people don't know how to govern themselves, then educate them. But you're not being allowed to be educated. In fact, I've got this ongoing argument with the Sydney University Law School and the Sydney University Senate. I said, put the curriculum of the law school on the table, and we can expose how they're teaching their students CRAP. In other words, they're not teaching real law, common law, the rule of law, due process. They are teaching their distortion of it to say, oh no, the judge has got all the power, the people don't have any rights, and we have kangaroo courts. There's a fellow in jail at the moment. He's got a website called Kangaroo Courts, Shane Dowling. But poor old Shane, he does not seem to want trial by jury. He calls them kangaroo courts, and he complains about judges being prims and all that sort of thing, but he won't put his foot down and say, no, it's got to be trial by jury. Because a jury, and I also say, oh, trial by jury is only for criminal cases. But that's totally lie after lie, you know. In fact, there's a very good article by a fellow called Lysander Spooner back in the 19th century. He wrote an essay on trial by jury, and he covers the topic beautifully, which backs up what a previous fellow 100 years before called Sir William Blackstone. He was also a big advocate of trial by jury. In fact, Sir William Blackstone called trial by jury the glory of English law. That's what he called the glory. In other words, and he said, if you don't have trial by jury, your country will eventually fail. And they all have seen in these other countries that haven't had trial by jury, and they've gone down tubes. And that's what happened to us. And we're going down tubes because we don't know how to defend ourselves. And all this complaining that's going on in all the websites and so forth, and people, they are only at the first stage of protecting their liberty. In fact, there's an American called Ed Hauschel. He said there are 4 boxes in defence of liberty. He said, number 1 is a soapbox, which is complaining, waving banners, walking up and down the street, writing letters. That's it, okay. And if you achieve the right result that way, well and good. Then the second one is the ballot box. The soapbox, the ballot box. And you elect people to represent you in the Parliament, in the debating house, to draw up uh, Acts of Parliament for the protection of your rights. Okay? And if they fail to do it, if they turn nasty and start bringing in bad laws, then we've got the third box in defence of liberty, which is called the jury box. Because the jury is where we have sovereignty, where we judge the facts and the law. And then we decide upon our conscience what is right and what is wrong. In fact, the word jury comes from the Latin word, iuris, which means right, law, oath. That's what jury means. So when you have trial by jury, you have trial by right, law, oath. That's how that works. And I've got various articles in there saying that no, courts are actually government. Because government means to control or be under. So when you have the wrong people in government, that's when it all goes wrong, see? But if you have the right people in, that's when it goes right. So what we've got in our courts are the wrong people. We've got judges, and we're not being allowed to exercise our own consciences and run our own country. In fact, this happened again in England, and they had to bring in an Act of Parliament called the Declaration of Rights, or the Bill of Rights. And it said very clearly in that various evil councillors, judges and ministers were endeavouring to subvert and extirpate the laws and liberties of the realm. That's what they're doing now. And this is what in court I'll call these people evil. They say, oh, you're being insulting. I say, no, that's the word in the law. In our Bill of Rights. And when people say you haven't got a Bill of Rights, again, it's a lie. We've got the best Bill of Rights of all, which is Magna Carta. We've got confirmation of charters. We've got petition of rights. We've got, what's the other one, habeas corpus. All these things are our laws. We have inherited from England. But when Philip came here, he brought English jurisprudence. He brought English law. And for the first part, it was purely an appeal colony, with the governor having absolute say. But then certain freemen in the colony said, no, we want all our rights as if we were living in England. And people like William Charles Wentworth, he spearheaded the whole thing. He said, no, we've got to have trial by jury. So in fact, William Charles Wentworth, just across the mountains and all that sort of stuff, but he was the best advocate for trial by jury this country has ever had. He was the one who went to England and got the Australian Courts Act put through in 1828. Okay? And so in fact he was the one who founded Sydney University. And that's why I tell these people at the university, I said, there's a picture of William Charles. He'd be turning in his grave if he knew what you were doing to his university, to his country, because we are surrounded by so much covering up. This Royal Commission into Bangi is a sham. It's a sham. I put in a submission to it at the very beginning, and it was on that variable interest rates. Variable interest, because under common law, under contract law, you can't have uncertainty in a contract, because a contract is an agreement which is duly executed and legally binding. And there are 8 essential elements for the creation of a contract: offer, acceptance, legality of purpose, genuine consent, and certainty of terms. So if you do not have certainty of terms, there is no contract created. But the banks didn't like that, because they wanted to muck around with interest. If their balance sheet was down, they'd stick interest rates up. So you can't do that and have a contract. And so I took this case to the Supreme Court. I said, I want the variable component severed from the contract. And the first judge said, oh no, the rate's indeed certain. Otherwise he lied. And then I appealed, and they agreed with him. Now in the High Court. And the three judges in the High Court, Dawson, Tilley and Kirby, I said, first question, does variable mean uncertain? So you can't ask that question. You can't ask. I got the transcript. It's all in transcript. Okay? So the High Court is another kangaroo court. And with these senators being turfed out, being disqualified, kangaroo court, kangaroo court, kangaroo court. Because never has anybody given their consent to have summary jurisdiction. So if you don't want a jury, and you're entitled to say, no, I don't want a jury, I don't want to bother, it's too straightforward, then you've got to sign a piece of paper called a memorandum of consent, giving your consent. And if the court does not have that memorandum of consent, then the court has no jurisdiction. No jurisdiction. It's happening every day. There'd be, I don't know, 500 courts in Australia. Not one court is telling the people of their rights. They are all kangaroo courts. And they are all profit-making things, and that they're all destroying people's rights. There's been, a couple of years ago, there was a farmer up in Moree. He'd been going to the Land Environment Court, but he never got a jury, never ever. And it was always the judge who said, no, this is what the statute says, this is what's going to happen. So he got so sick and tired of it, the next time this inspector came to his property, he shot him dead. Okay? You know, yeah, the internal. And so big hoo-ha about that. But the thing is, even the judge said, the laws may be wrong, but you can't react that way. So he's admitting that these laws are wrong. That when you have trial by jury, you have what they call jury nullification. In other words, the jury judges the facts and the law and determines the justice of the law. And if they decide that law is wrong, they'll disregard it, they'll nullify it. So that's what we have the power to do. And this is why the parliamentarians don't want you to know that. Because they think they're God Almighty, and they think they're lawmakers. They say, they say, oh, we're the government. So you're not the government at all. Even if we had the old monarchy system, Parliament was still Parliament. The talking shop, where they would draft a bill for an act. They would draft a bill for an act. And then they have a little bit of paper, and they go along to Government House. Government House. Because that's where government took place. In Government House. With the Governor General, or the State Governor. And he or she would say, oh yes, no, I'll give it a royal assent. And then that came into force as a statute law. But no matter what the statute law is, if you are charged for not paying your GST or something like that, then you can stand up and say, no, this law is wrong, and the judge will only rubber stamp what the Parliament says, but a jury, if they are a good jury, a fully informed jury. That's the operative thing. Not a bunch of deadheads. Okay? You want a jury of intelligent, competent, independent, and unbiased people. This is why you have jury selection. And so, but what happens now? I had one trial, but it was a mock trial, and they said, oh, okay, we'll give you trial by jury. I said, good. So they started bringing these people, and I started asking questions. Oh, you can't do that, you can't do that, you can't ask them questions. So in other words, I could only challenge, in other words, I could only knock back 3. The rest of the 9 just automatically went in. And even then, that so-called jury did not swear an oath. Jury means right or oath. They swore an affirmation. It doesn't make them a jury. A jury has to swear an oath. But it's as simple as that. But anyway, and what this jury said, at the end of the day, I said, okay, you people in the jury, go home, switch on your internet and find out what your rights and responsibilities are. Find out what you're supposed to do. Okay? And the judge says, no, you will not. You will not go anywhere near it. He told the jury, you will not find out what you were supposed to do. I will tell you what you're supposed to do. Oh, yes, okay. And this is what, there's another little cartoon I reproduced where you have this caption saying, do judges commit felonies? Because they manipulate the jury. And the jury, another cartoon said, well, what am I here for anyway? It's exactly right. Even when they have a jury, the judgment doesn't come from the jury. At best, they'll come up with a verdict, which will say, oh yes, he's guilty or not guilty. And then the judge says, oh, go away. I will give the judgment. You can't. According to that, it's the lawful judgment of the jury. So every single, even when you do have a rare occasion of having a jury, that judgment is void. So you might have the worst bugger in the world. It might be a rapist and a serial killer, and he should be put in jail. But he's got to be put in jail lawfully, according to the lawful judgment of free people. And that's what this caption around the front says. It starts off with, no free man. And that's what it's all about. We're either free men with the right to trial by jury, or we're slaves with no right of consent, no right to property, no right to trial by jury. And every time you go to court, you must have a jury. So even if it's a parking fine or whatever, if you think you've been unjustly dealt with, say you overstay a parking meter, and they charge you $350 or whatever it is, and say, that's all right. Fair enough, I should pay a fine, and maybe $50 is enough. But no, the judges say, no. So you can challenge the jurisdiction in any court. In fact, another time when I was in High Court, I was having an argument with Michael Kirby again, and he said, would you have trial by jury in the family court? And if ever there was a place for a jury, it's the family court. And I said, in any action. He said, would you have trial by jury for spitting on the footpath? I got interested. I said, in any action. Because every time, you've got the right of consent. You've got the inalienable right. That means a right which cannot be taken away. You can't even give it away. It cannot be made foreign to you. It's inalienable. It's yours. So, a lot of importance is on words. You know? Before you discuss anything, you've got to clarify the meanings of words and what they mean or where they're going to. So, you must consult the Oxford English Dictionary, because that's where our heritage of English is based. So every time there is any issue, and there are thousands and thousands, whether it's coal seam gas, whether it's immigration coming in, or whatever, every single issue, it's up to the people to govern their own country. Because the Parliament is failing, so therefore you go to the third box. And you say, okay, the fracking is wrong, it's destroying it, and you put the evidence to it, and it's determined, judged by a jury, and they'll determine what is right, what's wrong, and the right course of action. Because when they decide upon the right course of action, that becomes a court order. And if you don't comply with the court order, that is contempt of court, and you go to jail. So all these bankers and all these mining companies, whoever it is, if they don't comply with the jury's order, you go to the civil order, long way. And that's how you get your country back. You get your country back by going back